So I'm afraid it's not possible to devise any neat formula to identify the standard of review in all cases. One way of looking at the matter, which is pursued by Judge Yeager in his article, is to pick up on a tripartite classification which was advocated by another judge at the Court of First Instance, as it was in Luxembourg, Christopher Bellamy, who said, first of all, there are primary facts or basic facts. What happened? Did a meeting take place? Was there a telephone call? Was an agreement made? You can see an example of the control of that sort of primary fact in some of the recent judgments, for example, in industrial bags, such as Stemper against the Commission, where the court looked very carefully at evidence about whether a certain executive from a company was present at a cartel meeting. I think if I remember the facts of the case correctly, it all turned really in the end on bills from restaurants and bars to show where he was at a particular time when the cartel meeting was said to have taken place. Those are issues of primary fact which have never been subject to any indulgence or discretion by the court. The court has, however, recognized that the Commission does face particular difficulties in proving even those primary facts when the matter to be investigated is something which by definition is clandestine and secret. So we have the dicta in the seamless tubes cases about how the Commission is entitled to draw inferences from fragments of information. And then more recently, given the growing importance of leniency statements, it's interesting to see the court has been quite favorably disposed towards the credibility of evidence given as part of the corporate statement by companies applying for immunity. This is a subject which is still being litigated quite intensively on a number of fronts before the court, and with reference to what I said earlier about KME not answering at the level of the Court of Justice in Luxembourg, that question of whether competition proceedings are to be classified as criminal or not, that leaves unresolved, for the purposes of Luxembourg, the question of to what extent Article 6.3d of the Convention on Human Rights is relevant. That's the article about the right of a person accused of a criminal charge to cross-examine those giving evidence against him. It's very, very difficult to persuade the court in Luxembourg that a witness should be heard, but there is Strasbourg jurisprudence to the effect that where witness evidence is the sole or decisive evidence against a person, that evidence shouldn't be adduced without the accused having the opportunity to test its credibility by cross-examination of the witness. And in the Commission system, there is no right for the Commission or any party to an investigation to require the presence of a person at the Commission oral hearing that precedes the adoption of a decision, and certainly no right to subject that person to cross-examination. And then after the decision has been adopted, even if the decision does rely on evidence given by that person, the court has generally preferred to rely on the written statements corroborated by other documentary evidence rather than rely directly on the statement by the witness alone, tested by cross-examination. Cross-examination of the witness is arguably not necessary, even if you give full effect to Article 6.3d, if the witness statement is corroborated by, notably, other contemporaneous documents. Then there's the second and perhaps most difficult group of facts in Judge Bellamy's tripartite classification, which are facts of an economic nature. such as what is the relevant market, what is substitutability, is there a dominant position? And I would just draw your attention to a fairly recent judgment, MasterCard against the Commission, where the court gave what appears to be a fairly wide latitude to the Commission on the question of the definition of the product market, saying that that involves complex economic appraisals and that the definition of the relevant market is amenable to only limited review by the courts of the European Union. So that's not quite consistent with what Judge Yeager suggested in his article, which would have confined the category of complex economic appraisals very much to things at the policy end of the spectrum. On the other hand, it does appear to be consistent with what the Court of Justice said in KME. And how limited the review is to be is not always consistently stated. There's the transposition, as I've mentioned, of the Tetra Laval dictum into cartel practice in KME, and then that's been taken over in the MasterCard judgment, but in a slightly more succinct form. Then, paradoxically enough, when we get to the third category of facts, which are almost entering the question of policy in Judge Bellamy's final classification, it's interesting that, in fact, in the MasterCard judgment, the court there reproduced more or less in full the Tetra Laval dictum about ensuring that the evidence is factually accurate, reliable, and consistent, and whether it contains all the information which must be taken into account. And it did that in the context of assessing an argument that Article 101.3 was satisfied by the MasterCard interchange fee. So whereas the court appeared to be relatively generous about accepting something as a complex economic appraisal with respect to the question of market definition, it used a stricter variant of the formulation when addressing something which is generally accepted to be almost a question of policy. We could add, as I suppose, as a sort of subcategory of category 3, or as a fourth category, the question of control of the legality over the calculation of the fine. This is not unlimited jurisdiction, but simply control of the legality over the fine, where the court has traditionally given the Commission a fairly wide latitude, but here, if we return to the actual subject matter of KME, one striking thing that does emerge quite clearly from KME is the insistence that there must be full review over the legality of the Commission's fine. So that raises a number of questions about future practice. The court has traditionally been quite generous to the Commission in reviewing the extent to which the Commission correctly assessed the added value of a leniency applicant's contribution to the evidence underpinning a decision. But of course, the discount given for leniency is all part of the calculation of the fine. And KME seems to suggest, therefore, that the court will need to scrutinize in greater depth questions about whether a party's contribution merited a greater reduction in the fine than was given. That said, I noticed that in some quite recent general court judgments, methacrylates, hard haberdashery, and Dutch bitumen, the general court is still talking in terms of wide discretion over fines, although it may be that on the substance there isn't so much of a difference, because as the court said in KME about the general court's judgment in that case, even though the general court had used the language of manifest error of discretion, the actual review carried out was quite detailed. And indeed, if you look at those cases, you'll see that although the court uses the language of wide discretion in assessing the value of the leniency applicant's contribution, it is nevertheless assessed in some detail. So it remains to be seen whether a formal shift in the standard would result in significantly different results at the court. There are dicta in the cases in Strasbourg that suggest that full review must extend to the court actually replacing the administrative decision maker. But I think that goes a little bit too far. The court talks in Menerini Diagnostics at paragraph 59, for example, about le pouvoir de réformer en tous points, which literally translated seems to suggest that it is for the court to remake the decision. That can be done in some national systems. For example, the Competition Appeal Tribunal in the United Kingdom can remake the Office of Fair Trading's decision. But I don't think that's really an issue of the standard of judicial review. That's rather a secondary issue about the consequences of judicial review. I don't think there's anything objectionable from a fundamental rights point of view about a court having exercised full review, finding that the authority's decision is defective in some way, but then simply annulling the decision and leaving it in the hands of the authority whether the decision should be readopted. Turning to unlimited jurisdiction over fines, because time, I see, is marching on. As you know, there's Article 261 providing for unlimited jurisdiction in the treaty, which is implemented in Article 31 of Regulation 1/2003. A few preliminary points to make about unlimited jurisdiction. Menerini Diagnostics confirms, I think, that such a system is acceptable. Fines can be imposed by an authority with full review being provided for by a court. Another question which perhaps we haven't got time to get into today is whether the influence of Strasbourg will make itself felt on the question of whether fines can be enforced pending judicial review. Then coming back to the treaty itself, there's the question of whether Article 261 is a sufficient basis itself for review of all aspects of the decision or only for the fine. I think it's pretty clear that it's only as regards the fine, and that seems to me to have been confirmed by KME, but I've noted in a footnote some dissenting voices in academic writings. It's also important to note that unlimited jurisdiction doesn't mean unlimited debate before the court. As the court again confirmed in KME, it's for the parties, for the applicant to raise the arguments and evidence that it wants to invoke in support of its case. There's also the interesting question of whether there's any limitation period for bringing an action seeking the court's exercise of unlimited jurisdiction. This arose in the French beef cases where somebody missed the limitation period for bringing an action for annulment. Said, well, it doesn't matter because I'm not seeking the annulment of the decision under Article 263. I'm just seeking the application of the court's unlimited jurisdiction to review the size of the fine. And that didn't work. The court held that one had to respect the limitation period of Article 263 because the exercise of unlimited jurisdiction was linked to legality under Article 263. I'm not entirely convinced that that is correct as a reading of the treaty, but it's clearly an understandable pragmatic reaction to the possible spectre of calls for the court to exercise unlimited jurisdiction over fines emerging years after the decision, perhaps. In practice, people almost always bring their cases under Article 263 and Article 261, so it doesn't usually arise. But I think it must be clear that as a matter of law, you don't have to have an annulment to any extent under Article 263 in order to trigger the court's jurisdiction to reduce the fine under Article 261. That said, as a practical matter, the cases show that it's very difficult, indeed, I would say these days impossible, to persuade the court to exercise pure unlimited jurisdiction where the court finds no fault with the substance of the Commission's decision, but nevertheless decides that in exercise of its unlimited jurisdiction, it's going to reduce or perhaps increase the fine. The court has been quite an enthusiastic adherent of the Commission's fining guidelines. They're described as acting in the interests of transparency in KME, and it's very much tended to follow the fining guidelines when it has adjusted the fines. One of the judges at the General Court, just speaking to me informally, said that he thought it would be very undesirable if the court were to exercise unlimited jurisdiction in an unlimited fashion, because it would lead to a degree of anarchy and unpredictability. Different chambers would have a different approach to fines, so that instead of there being a set of guidelines on fines issued by the Commission, providing some consistency and predictability, any Commission guidelines would be of no real significance, because the level of the fine would be very much a matter for the court, and their different approaches would be taken by different judges, and he thought that that was rather undesirable. So these days, in order to persuade the court to exercise unlimited jurisdiction, it's necessary in practical terms to find some substantive failing in the decision. Once you do that, then you're sometimes better off and sometimes not as well off as you might have thought that you might be. There are cases that work both ways. There are cases where someone has succeeded in, say, reducing the duration of the infringement quite significantly, but the court, in exercising its unlimited jurisdiction to adjust the fine, has not reduced the fine to a degree commensurate with the reduction in the duration. Or there are other cases where the reduction has been more generous than would have been the case had the fine been fixed in the light of the revised findings of the court by reference to the fining guidelines. When I was making my way up here, I noticed that a little way north of here on the map is the Villa Grazioli, which rang a bell with me as a participant in the Italian raw tobacco cartel litigation, since the Villa Grazioli was the scene of one of the cartel agreements. And one of those cases, the Romana Tabacchi, is an illustration of how sometimes you can come out better than you would have done if the Commission had correctly judged the duration or gravity of the infringement in the first place, because there the court set a fine which was lower than the fine that would have been applied had the Commission simply done it right the first time in applying the fining guidelines. Then there are some cases more recently which are interesting examples, perhaps illustrating the court's deference to the fining guidelines, where the court, having found substantive fault with the decision or with the methodology by which the Commission had fixed the fine, simply annulled the fine. In one case, Aragonesus, expressly inviting the Commission to go away and come up with a new fine. In other cases, Toshiba and Mitsubishi, which aren't mentioned in the handout, where implicitly the court has invited the Commission to adopt a new fine using a correct fining methodology, which is what it did. It's a surprising abstinence, some might think, from the court exercising its own unlimited jurisdiction. But I think the explanation lies in the fact that the court sees desirability in the predictability of the application of the fining guidelines, and sometimes the application of those guidelines is quite technical, and so the court decided to hand it back to the Commission in those cases. Well, I must hand over to the next speaker because I've taken up quite a lot of time, I think. So pending any further discussion, I will conclude my remarks there. Thank you.